As things currently stand, you only get 3 months to bring an employment tribunal claim for discrimination. That's changing in October this year. It's being extended to 6 months. But you get 3 years to bring a claim for personal injury in the county court. If a client comes to see me out of time for the employment tribunal claim, then it makes that decision process a lot easier, because it's an easier claim to bring in the county court because you're not out of time on day one. It could be to do with foresight. It could be that a client hasn't quite met the legal thresholds for a particular claim. It might be that the evidence leads us to advise that one claim should be preferred over another. It could be as rudimental as funding. Typically, lawyers in employment tribunal claims tend to need to be paid upfront by their clients because the rules on fee recovery are different in the employment tribunal. Not always, but that's certainly a key feature because litigation can be expensive. Whereas claims in the county and high court tend to be funded on conditional fee agreement terms, otherwise known as no-win, no-fee deals, which means there are no nasty lawyers' bills up front, and there's a lot of risk which is passed to the solicitor undertaking the work in exchange for a contribution towards costs from damages should the claim be successful. There are also no adverse costs in a personal injury claim, so that means if you lose your claim, you don't even have to pay the other side's costs. There are a few exceptions to that, including fraud, etc., as you might expect. But actually, sometimes a claim is preferred in the county court simply because of funding restrictions. So there are lots of things that go into deciding which is the best route. If we're talking about civil litigation and a personal injury claim, there are various steps which an individual needs to undertake in order to bring a claim in the first place. This is something which I don't expect any clients to be aware of. That's very much the responsibility of those advising them. But it does help to have a bit of an idea of what's involved so an individual can make an assessment, is this something that I want to go through? And what goes hand in hand with the steps, I think, are the realistic time frame involved. So if a decision has been made to pursue a claim, and let's assume the initial investigative work has been undertaken, the process is started with a letter. Sounds dead simple. We don't involve the court yet. Civil claims are governed by a pre-action protocol, and that protocol starts with the claimant writing a formal letter to the employer, putting them on notice that a claim is being initiated,